we thought rather than just actually stick to SRA for the full hour, I was slightly concerned that some of you might just burst into excitement, just the prospect of that over the next hour. We have decided that we will feature quite a lot about SRA. We're then going to actually deal with some specific risks affecting law firms. And then we'll have a few minutes or so dealing with takeovers and mergers and some of the risks that are associated with that. So because it is badged as an SRA gig, really, I'd like to just hand over to Chris. And Chris, just tell us what is actually going on the SRA horizon, because you can see there's a lot of excited people out there.
Great. Well, no pressure. SRA gig. I wasn't quite aware of that. Thanks very much. So I'm going to talk a little bit about our review of our handbook. So I assume you're all familiar with the SRA handbook, all 400 odd pages of it. Well, we're reviewing that at the moment, and what we're trying to do sort of ties in with the themes that we've already been discussed today. We're trying to do more to allow flexibility for solicitors and for firms to innovate, to compete and grow. The polls at the beginning asked kind of what's getting in the way of people doing that. What it didn't mention was regulation, but actually surveys that have been done of firms recently show that legislation and regulation is seen as one of the barriers to firms being able to change, to compete and grow. So we're trying to do something about that. And sort of underpinning all of this is that we're trying to improve access to solicitors at an affordable price for the public, for businesses, etc. So two main strands to our review. First of all, we're looking at those 400 pages of handbook. We're trying to make our rules shorter, clearer, and easier to understand. When I go out and talk to people, then quite often I'm told that it's just too big, too complicated. It's really hard to navigate. So trying to do something about that. So to start with, we're looking at some of the key things: our principles, our code of conduct, and our accounts rules. One of the big changes that we'll be proposing is to look at the code and have two separate codes of conduct. One for solicitors, a very short code that will apply to solicitors wherever practice, and that's really about capturing those core standards that a solicitor should be personally accountable for wherever they practice in any circumstance. And then a code for firms, which much more concentrates on business processes, controls, the things at that business level. Another thing I hear about all the time is the you problem with our current code. The code is 30 odd pages long and it refers to you the firm, you the solicitor, you the manager, you the employee. What does all of that mean? So, I mean, the plan at the moment is to go down from 30-page single code to, at the moment, around 11 or 12 pages covering both. So much shorter, more concise codes and segmented in that way. The second key strand to our proposals is to have greater flexibility about where solicitors can practice. So the key change here really is to allow solicitors to deliver certain legal activities, those that legislation don't restrict, to the public outside of firms regulated by the SRA or another legal services regulator. Normally this kind of point when I talk about this, I ask about the reserved legal activities. Are people familiar with those? Do they know what they are? A mixture.
Canter through them again. There's one or two glazed looks out there, but that just might be the beer they had on the way in on the train.
So there normally is. When I speak to any kind of audience, there normally is. But the reserved legal activities are in essence what Parliament, what legislation says can only be undertaken by authorised people within firms that are authorised and regulated by SRA or another regulator. So there are things like conduct of litigation, rights of audience in some courts, probate activities, but only a narrow part of that, the preparation of the forms to go to the probate office. Some parts of conveyancing, reserved instrument activities, administration of oaths, and notarial activities, which I think are defined as something like what notaries normally do in the 1901 Act or something. So that's it. So outside of those reserved legal activities, anybody can set up shop and deliver legal advice. So the ones that are most commonly known are things like will writing firms, Mackenzie Friends, etc. But in reality, any other activities, most general legal advice, most work done in the city can be done by anybody. You don't have to be authorised and regulated by a legal services provider. So actually, the only people that can't deliver services within those sort of unregulated businesses at the moment are solicitors, and that's because of our rules. And we think that solicitors are perhaps uniquely placed to bring their expertise, their ethics, their kind of knowledge into those firms. So why shouldn't a will writing firm have a solicitor in it helping deliver services to the public? So that's where we're going well, that's what we're proposing with a change to our practice framework rules. And it'll also help in-house solicitors potentially be able to deliver services outside of to those other than employers, and just make it easier for solicitors and other professionals to join up as well. Why are we looking to change, I guess is the next question. There's lots of reasons why we regulate and why we look at reviewing our regulation. We have statutory regulatory objectives set out in the Legal Services Act. We have to take account of the better regulation principles, things like being proportionate, targeted, transparent, accountable, and other sort of standards of better professional regulation. But the real reason, I think, or one of the key reasons, is to help the public access good quality legal services from solicitors. So research out there at the moment shows this huge unmet need with legal services, particularly among individuals and small businesses. Legal Services Board have commissioned a lot of research in this area. Of all individuals, members of the public, people on the street that have a legal problem, 80% of them don't get any professional help at all. If you look at small businesses, 83% don't get any professional help. And if you are a small business with a legal problem, you're more likely to ask your accountant than a lawyer or law firm at the moment for help. Reasons for this, I mean, there's lots of them, but the ones that keep coming up are cost. I think only 13% of small businesses say that they think that legal services provide value for money at the moment. Affordability is a big issue. And also, more generally, familiarity. People say that buying legal services, it just doesn't look or feel like other services that they buy, so it's alien to them. And the time it takes to try and familiarise themselves with that, it just makes it all a bit too daunting. So that's another thing that comes up, particularly with individuals, but also small businesses. So what can we do about this? Well, I think the first thing is just reducing that regulatory burden, reducing barriers, getting rid of some of the real prescription and detail in our rules that can tie firms up in knots, but doesn't really concentrate on the really important things that we're trying to protect and standards that need to be upheld. I think the current accounts rules, really good example of this. About 43 pages long at the moment, I believe. And when we collected accountants' reports from every firm, we got about 9,000 in. Half of all firms were in breach of our rules at any one time. So half of firms in breach of rules. We would take further action, look into more about 200 of those because there was possibly an issue that needed looking at, a serious issue. And I think around 20 end up in the SDT. So if that's where there's harm, but half of firms are tying themselves up in knots trying to comply and failing, then that suggests there's something wrong with those rules. They're just too difficult, too detailed, and sort of really hard to comply with, in fact. So why else? Well, competition has been mentioned today, and I think in particular this growing unregulated sector. So I've mentioned reserved legal activities, and anything outside of those can be delivered by people totally unregulated. And that market's increasing. So research from the Legal Services Board again recently, I think, suggests up to 30% of all legal services are delivered totally outside of regulation, and that's a growing number. I said will writing, Mackenzie Friends are sort of the really well-known ones, but actually the main areas are things like debt, housing, and all sorts of kind of commercial work, increasingly being delivered outside of law firms. And as I said, the only people that can't deliver services within those firms at the moment are solicitors because our rules stop them. I think another important thing is one of the things I hear all the time is that we just change our rules too often, and it makes it really hard for firms to keep up, and that is in itself a barrier to innovation and growth. I think we're on around version 16 of our handbook, which came in 2011. I think that's quite a lot of change. And part of the problem is the way that it's sort of written at the moment. It kind of suggests that there's a standard firm, a kind of traditional law firm, and things should be delivered in a certain way, and tries to write sort of prescriptive rules around what you can and can't do to fit that picture. but that's not how the world is anymore. I mean, things have changed. The variety of different types of legal services out there is massive. The increase of things like online services, subscription services, kind of outsourcing, all sorts of things changing, and consumers are looking to buy things differently. I did some focus groups quite recently with just people on the street, asking them what they do when they have a legal problem. I think maybe sort of in the old days you might think, well, you go to your solicitor, you get a recommendation or whatever. Recommendations are still really important, but everyone in the focus group said we Google. We look for our problem on Google, see what comes up, see what advice is out there, see what types of providers pop up and go through them. So things are really changing there, and I think we'll see increasingly the growth of comparison sites in the future in this area as well. So that's kind of like what we're doing and why. So we're looking at the first stage, which is the principles, codes and accounts rules, and the key proposals about where solicitors can practice. We're looking to consult around June, well hopefully June, maybe July. We're going to do a really long consultation on this, and we've had lots of engagement and continue to do lots of engagement already, which I really encourage you to get involved with. We have virtual reference groups which you can sign up to, which means that you get sort of sneak previews of everything, and we invite your views on it. So things like the drafts codes of conduct have already gone out there to people on those reference groups. We get views in, we take them into account in coming up with our final proposals. We're also planning during the consultation process to do lots of engagement, including things like technical webinars where we'll go through the codes in detail and what they mean and answer questions about them. So that's coming up in June, perhaps July. And then phase 2, which is in effect the rest of the handbook. We'll do a consultation on that hopefully early next year. And implementation is a little way off. We'll give plenty of notice and help people work through this if we make the changes. And that's end of 2017 at the earliest, I would think. And just one more thing I want to say here is that we're kind of learning our lessons from 2011, where we moved to outcomes-focused regulation. And we kind of said, here's your outcomes, you're accountable, you're responsible, you're on your own. So we'll do much more to help those firms that need help, those solicitors that need help understanding and complying with our handbook. We'll give them more support. So we'll talk throughout the consultation period about what that looks like, and again, we already have been. But we'll look at things like toolkits, case studies. We've done quite a lot of different things with our changes to continuing competence and consumer credit rules, where we do much more sort of interactive online stuff rather than just pages and pages of guidance that look a lot like rules. Part of our consultation will be sort of crowdsourcing case studies and areas where people want us to focus some kind of compliance support on. And another thing we're looking at is if there's kind of groups out there that want to write guidance for their members, then we'll look to endorse that guidance. We won't give safe harbour on individual cases, but we'll look to kind of say that we think that that's broadly okay. So that's quite a big change for us. And one last point I'd like to raise is that we also have we've also started SRA Innovate, which I don't know if anyone's familiar with, but SRA Innovate, have a look on our website about that. So in effect, we offer support for existing firms, sort of any new firms that are looking to deliver or change the way they deliver services to in any way, really. So lots of support for them there. So how regulation might fit with that, how you can go about getting authorised if you're a new entrant. Practical examples of what other people have done and kind of guidance around that, and increasingly working towards a kind of sort of safe space where you can talk to us about what you have planned. If it looks like it's a benefit to the public and to consumers, then we can see whether we can give you a sort of safe space to work some of the detail out in. So I advise you to sort of have a look at SRA Innovate on our website.
What kind of things are people innovating? How are lawyers being creative in this kind of space, the safe space that the SRA has created?
So, I mean, lots of this is things that we've been doing. We're formalising things that we've been doing for a long time around our ethics team will help people understand regulation and new entrants. With our authorisation teams, there's loads of different stuff. We did some research into innovation, and innovation is it's a bit of a term that can mean anything. It really just means sort of changing the way you deliver services, doing things differently. We get all sorts of stuff. Building on the kind of the remote and virtual working theme that was raised earlier, then we've had or people coming to us saying they want to set up a virtual law firm where everything's done remotely with consultants, etc., and asking questions of us like how could supervision work in this environment? How do we manage kind of conflicts and confidentiality issues, things like that. How do we ensure that people are competent? So we offer advice on how that kind of model would fit with our rules. Another kind of good example is we were approached by a firm that was wanting to respond to a crowdfunding idea for clients that were no longer eligible for legal aid, where there'd be crowdfunding sites that would in effect pay for that individual to get help when they were in trouble. So questions around how that would work with our requirements around managing client accounts, client money, etc. And we offer practical advice on that. And then also things around how do I structure myself to get in investment, etc. So do I need to become an alternative business structure? And if so, how does my kind of ownership and management structure make that as easy as possible? And we get all sorts of different types of people approaching us about that, from kind of local authorities that want to offer services, want to sell services in a more corporate way, through to law firms or professional services bodies that in other areas that want to get involved in legal services a bit more. So all sorts of different things.
Okay, interesting the thing about the virtual law office. I'm old enough to remember Andrew Woolley, and I think somebody from Woolley & Co.'s in the audience, but I remember Andrew Woolley talking about when he set up his virtual law firm, how the SRA were very anti it on the basis that there was nowhere for them to intervene on, and it was things like that. So we've kind of come full circle from Andrew to to now the SRA embracing that. Just wonder whether we can presumably if the good folk in the audience want to get involved in the consultation process and have details of these webinars and forums and things like that, they registered on the SRA website?
Yeah, so there's we have web pages called Looking to the Future, a section on our website, and that gives you details of everything that's happening, how you sign up for our different reference groups, consultation events that are happening, and also just an open sort of forum where you can just tell us what you think's wrong with the current handbook, what you'd like to see in the new handbook, areas that confuse you, sort of that kind of thing. So really can invite views in lots of different ways.
And how long have those pages been up?
They've been up a few months now.
Okay, and can we have a show of hands? Because I'm not expecting to be blown away by the response. How many has anybody in this room registered on that website?
Hi.
Not one. There you go. So, but at least we've heard it here. So I will register tomorrow. So you'll get one lead out of it anyway. You. But I think there's obviously a lot going on if we want to engage with that. I suspect.
It is the way to input, but also, as I say, just to get sort of sneak previews, keep yourself up to date on what might be happening. So putting the draft codes out, that's quite a change for us. So putting codes out there that haven't even been near our board, it's just this is what we're thinking. This is a rough worked up example. What do you think? It's just a different way of doing things. We're trying to kind of engage a lot more and listen to what works for the solicitors and firms.
Chris, one last thing.
Yeah.
Question of trust.
Question
of trust campaign.
Yeah.
The trust that the public have in lawyers.
So I mean, is anyone familiar with our question of trust campaign?
About 5. Okay.
So this is a big campaign that we ran recently. The idea is really to help the SRA sort of be a lot clearer about what we think serious in terms of sort of breaches to our codes and rules, and also to ask the public and ask the profession what they think, and also just a way to engage with people on regulation in a way that they wouldn't normally. It's quite it's not the most glamorous subject, so to try and get the very public engaged in regulation is quite difficult. It's just a novel way of doing things. So what we did was through lots of different mediums, we asked people. We put to them certain scenarios where a rule's been breached, code's been breached, and asked people how serious they thought it was and what kind of action that should result in. We did loads of stuff. We've been out on the road with Who Wants to Be a Millionaire, and then asked the audience technology. We kind of used that and went out, put the scenarios up, and people just voted there and then saw what the results were. We did loads of sort of Twitter campaigns, social media stuff. We had postcards which just had a couple of scenarios on, and they would be sort of put out to different people, hard to reach groups where anything more would be a bit too intimidating. Fill those in. And all of this the results of this will eventually feed into a review of our enforcement policy, which is happening alongside the handbook. Very conscious that if we reduce rules, then a fear will be, well, then you're going to hit us with enforcement if we use our judgment. So we need to be really clear that enforcement won't be geared in that way. So we got about the views of about 5,500 people, professionals, wow, and the public on this campaign as a whole. We did online surveys where about half the responses were from public, half from the profession. We also ran a formal consultation. So can anyone guess how many responses we had to the formal consultation?
5%, judging by the number of hands that went up here.
34 responses to formal consultation out of 5,500 people offered their view in a different way. So I think that some lessons to be learned there about how we try and engage with people as well. Reading pages and pages of dull text is not what people really want, and we'll be doing that and looking to the future. Findings of question of trust. We'll be putting all the results out soon. There's a question of trust page of our website as well. But some of the key findings on what people think is serious, I guess no massive surprises there. Nicking the client money is always serious.
Hang on, I need to make a note.
Make a note of that. Sort of forging documents, misleading the court, etc. Always serious. And using your unique position as a solicitor to in a kind of an ethical way to benefit yourself. Very serious. Difference between the public and the profession, quite interesting. Not huge variation across everything, but two things that did come out quite clearly. Issues of competence, then I should say overall the public generally thought things a little bit more serious than the profession, but two areas where there was sort of stark contrast. Competence, issues of competence, public thought that was more serious. And a big one, which is perhaps where Natasha can come in a minute, is around confidentiality, keeping records safe. We asked 5 different questions, 5 scenarios on that, and on every single one, then the profession thought that sort of data protection issues were less serious than the public. I went out and did quite a few of the voting sessions, and one of the scenarios that had sort of arguments all the time was example of senior partner takes some papers home, leaves them in the boot of his car gets nicked, and then how serious is that? What should happen? Lots of solicitors, perhaps unsurprisingly, said, my car's just been nicked, come on. Lots of the public said, I don't care, that's my life, that's all my really personal details, that's crucial sort of business stuff. I don't care if you had your car nicked, you should have kept that safer. So real differences between public and the profession there.
Well, that does lead us nicely on to another example of risk and compliance. And Natasha, you're going to talk to us a bit about some of the data protection and some of the horror stories that you may have come across.
I'm not going to share the horror stories.
All right, oh, okay.
But
mind them.
Yeah, so I know you're all really rearing to go with data protection, but whether we like it or not, this is going to affect everybody within our sector. So the General Data Protection Regulation is a new regulation from the European Commission to replace the existing Data Protection Directive. It has taken a total of 4 years to be approved from the first paper that was published, and it is the harmonisation of the data protection regulations throughout the EU. It enforces the control of both personal, client and employee data. And from the launch of this new regulation in spring this year, we have 2 years to get this up and running within each firm and each business within the European Union. The deadline is the 25th of May 2018. The penalties have now been greatly increased from a cap, which is under the current data protection of £500,000 for data breaches, to a 4% company-wide annual turnover. So that's quite a drastic change. If you're processing or storing personal information of any EU citizen, this would apply to your company. Personal information includes employee information as well as client information, addresses, national insurance numbers, copies of passports, addresses, email addresses, and so on. So any form of information relating to an individual from which they can be identified. The independent supervisory authority will run regular audits, investigate complaints, respond to whistleblowing, test your processes. We're currently expecting it to remain under the ICO body or another government-controlled body, but it looks like it's going to remain with the ICO. Every company is expected to be responsible and accountable, and this is half of the documentation of the new legislation. It is a very, very bulky document, and I've only managed to read it twice because it's only been out for 2 months now. But the ICO have done a really good job in basically putting together 12 steps. So I highly recommend you all go and have a look at the ICO website. On their homepage, there is a link through to a separate website for the GDPR, the General Data Protection Regulation. This is a great little handout, which I highly recommend. Going through this new regulation, I think there's kind of 6 main points that affect most of the firms within our sector. So firstly, the first point is awareness. So you have to let your managing partners, fee earners, secretaries, PAs, everybody know about this new regulation. You have to sell it, you have to get buy-in, and you have to make sure everyone knows what's about to happen. Secondly, they're highly recommending that every firm has a data protection officer. Now, that doesn't have to be a full-time job. It can be a part-time job, but somebody needs to be accountable and responsible for making sure this data is protected. Thirdly, you need to know what information you hold and where you hold it. So that goes from everything to your legal practice management software, to if you outsource your marketing, through to if you're contacting old clients. Do a full information audit and know where your information is. Fourthly, try and identify potential breaches. So that goes from everything from a fee earner taking files home in a car or on a train, all the way through to if you outsource certain bits of your marketing, where your data and where your backup goes to. This is so important because so many people now with their legal practice management software outsource their data backup. Where is that data going? Is it staying in the UK? Do other people have information to it? You have to really monitor all of this stuff. Now, another important point is consent. Do you all have consent from your customers to keep and maintain their data and also contact them in the future? Do you have their consent to contact them via email, via letter, via personal correspondence, via the telephone? You need consent for all of those methods. Sixth one is communicating your privacy information. So you need to review your current privacy notices and put out a plan in place for making any necessary changes for the GDPR. Now, this is a very bulky and boring document. It's great nighttime reading. But it is essential to what we're doing moving forward, and it is going to be a directive. It's going to be a regulation that is going to exist throughout Europe, and I know we're having a debate at the moment of whether we're going to stay in Europe or leave. Whether you like it or not, if you hold data, I think the UK is still going to have to be accountable for that data and accountable for any people's data that they hold as well. So we're also going to be putting this together and putting the steps together and hopefully getting together and write some articles as well for the LPM magazine, which will hopefully guide you and help you and give you some highlights and talk you through it. So yeah. But if anyone wants this link, let me know, and we're on the stand outside and I'm happy to give it to you. So yeah.
Okay. I won't ask you to name any names or anything like that, but if you've got a lot of solicitor clients, how many of them would you say are up to speed with protecting their data? I think most people, whenever you think about cybercrime and things like that, everybody thinks, somebody wants to get their hands on client account, not necessarily worrying too much about data.
So I think the thing that worries me the most, being in this industry and doing what we do, we see a lot of things when we go into our customers and we kind of, sit down and we go through the stuff with them. The worrying thing about the General Data Protection Regulation is that I know 2 years may sound like an incredibly long time. I personally do not think it's a long enough period to get all of these steps within each organisation. to do an information audit alone can take months and months and months.
Yeah.
So yeah.
That's encouraging, isn't it? Right.
Sorry.
What's the SRA? Has the SRA got a view on what we should be doing with our data? Is that forming part of your remit, Chris, or are people looking at that?
I don't know. It's not falling under the review of the handbook.
Okay. Well, you know, for businesses that have trouble finding COPs, COFAs, MLROs, now we've got to find a data protection person that, you know, who would want to be a sole practitioner is just another title as well. Okay. Right, we'll hand over to Mr. Lowe. I'm delighted Paul was able to join us because I'll let Paul tell you a little bit about his firm's background, but some of the recent administrative headaches regarding risk and compliance that you've come across.
Thanks, Shaun. I suppose this falls into two parts, actually. Firstly, the past, the period leading up to the end of January, and the firm I was at, being Darbys Solicitors, and the acquisition by Knights. And then, purely more recently, I suppose, in terms of my new vocation and my new role, which is to introduce change management into the firm I've joined, who are, I think, they would probably accept, a bit more akin to a barrister's chambers, and a collection of individuals who happen to practice under the name very successfully, in terms of profit and everything else, but in terms of regulation, management, compliance, risk, they need that to come on board. So there are two parts to this. So in terms of the past, in I think it was late November, it was announced that Darbys was being acquired by Knights. Knights, if you don't know, are on a big acquisition trail. They're a private equity funded law firm, and who made a decision, and the partners of Darbys decided to sell with a very, very ambitious timescale. So from announcement, from talks to announcement was literally weeks, and from announcement both to staff and to the public to completion was the end of January. So it was about 8 to 9 weeks, which included Christmas. So those of you who have been involved in mergers or acquisitions, that's ambitious. If you add to that Knights were determined on day one to implement their own working practices, they had already made huge investment in IT, such that their business runs on the basis that there is little back office support in terms of IT and secretarial support. So part of this process involved huge change management in terms of people, a lot of casualties, and I was one of them who left Darbys. So effectively in what was Darbys, there were about 50 secretaries. On the first day of acquisition, there were 4. Secondly, they, again, unlike any other acquisitions that I'd dealt with before, on day one, they were working on their new system. I thought it was pie in the sky that would actually happen, but it did, and fair play to Knights when they said they were going to do it. They and their suppliers, and with a lot of assistance from us as well, we got there, and the data that was within Darbys on the Darbys practice management system was transferred to Knights on day one. And I think there's, to be fair to them, a lot of sense in that. And talking about risk and that sort of thing, you effectively had all the data in one place rather than spread across different systems, and it would obviously allow them to produce management reports easier. The other area, in terms of that timescale, was dealing with all of the regulatory bodies. So obviously you've got SRA to deal with, but perhaps areas that people hadn't really thought about and caused issues. So both firms had CQS accreditation issued by the law society. So there's the whole process. I mean, anybody who's been through that process will know that it's a challenge. So the process of bringing those two together. Linked to that was the issue that, if you think about it, when the announcement was made, many clients already had things like mortgage offers from existing suppliers, and was the question was, do those mortgage offers get changed to the new firm on the basis that completion was going to be after the 1st of February, or were they left within the Darbys organisation, and how was that dealt with in terms of professional indemnity requirements? So in simple terms, it was decided to keep the offers in the name of Darbys, so that completions that hadn't yet taken place, where mortgage offers, well, this is how I understand happened, because obviously I wasn't there, but in essence, the plan was that if you had a mortgage offer issued to Darbys, Darbys effectively would continue to deal with those completions, and the PI cover would cover that situation. Obviously, very important in their relation to that. So there was a whole range of issues there. Another issue was that Darbys was a legal aid agency firm. We had only very recently got new crime contract, new clinical negligence contract. Knights didn't have any contracts. So there was the issue of dealing with the legal aid agency, and that's a challenge in itself, and how you novated those contracts across. It wasn't thought of immediately. I think everybody just thought just novated across. And suddenly you start reading the rules, and the legal aid agency require a minimum of a month to consider novation and effectively who were going to be the new owners of the contracts within the firm. When I left, that still wasn't sorted, and again there was going to be a whole raft of ways. So the existing Darbys LLP, Solicitors LLP partnership, was going to continue not only for conveyancing transactions, but actually for legal aid work for a while, until such time as those contracts could come across, because otherwise, effectively, the new organisation, Knights, could not continue. So there's a huge administrative headache there. So I think one of the lessons is, it sounded a great idea from Knights' point of view to complete quickly. They were on a very ambitious timescale. In many ways, things that they could control, practice management system and things like that, they achieved. But actually, where you had to deal with other bodies and other regulators, things were still left in abeyance when I left on completion. It seems like the SRA have done a complete U-turn since the 2011 code, and I vividly remember attending sessions and lawyers scratching their heads thinking, how on earth are we going to deal with these outcomes and indicative behaviours? We're lawyers, we were taught to learn rules, and for the last 5 years, the number of times I was asked, well, what are the rules relating to this issue and behaviour, and having to remind those within the firm that actually there weren't rules, there were these fluffy things called outcomes and indicative behaviours. What's really led to that? Is it the profession that's caused you to have that U-turn? The LSB? What is it that's caused, on the face of it, quite a significant change to what's planned anyway?
Yeah, well, there's a few things. I mean, the main one is that our providers, those we regulate, are telling us that the detail, the prescription within our rules does get in the way of them doing business. And particularly in this changing world where people are looking to do things differently, driven by their clients, potential clients, and also by competition from others. The way our rules are written at the moment, they are trying to deal with a particular model in a world that's changing. So we're constantly trying to catch up and change our rules. And again, people telling us that constant change doesn't help. And I think that accounts rules example I gave earlier just really emphasises some of the problems with the current rules. But I do totally take on board the observation that some firms really do want more support, and having sort of higher level standards, outcomes, sort of concerns them a bit, which is why we are planning on building this sort of quite big support package. I'm really asking for views of people that will be using it. The codes will be out there. If you're on the virtual reference group, you already have seen some drafts. And really are just asking for views on what sort of stuff you think you need to help you comply. And we'll work with you, representative bodies, whoever else, to come up with the best package that we can to help. Some people don't. Some people don't need the help. Some people do. So trying to set prescription and real detail on the basis that everybody needs that when that's not true doesn't quite work. So let's target a bit more and help those that need help.
And Chris, I know when we spoke before,
Yeah.
a week or so ago, you talk about you spend quite a lot of your time out and about,
Yeah.
being proactive rather than reactive, and that, I must confess, came as something of a shock to me, you know, insofar as I probably have a more feeling of the old SRA. What are you out doing that is proactive, and what are forward-looking firms actually involving the SRA and inviting them in, as opposed to, you know, living in dread?
Yeah, we do all sorts of different things. And we have our own events that we hold. So we have our compliance conference, which I think 700 firms were represented at this year. We do things like we had an Innovate conference earlier this year, where about 120 firms who have an interest in innovation and looking to do things differently came along to. Some spoke at, shared experiences. And then also we do events like this, and we go out and see different groups. Our board is spending a lot of time going out, meeting local law societies, for example, so all over the country. So making sure that we're not just sort of sitting in London or in Birmingham, but really getting out there. I'm off to Cardiff on Wednesday to talk about the changes that we'll be looking to make with the handbook, and we're doing groups with consumers, with in-house lawyers, and with law firms. And then a separate session on the changes to continuing competence. So spend a whole day in Cardiff, just anyone invited in that wants to come, and we'll just talk to them, hear what their views are. And yeah, we do really small things like, so I quite often go to various sort of, say, breakfast meetings of compliance officers, where there's a handful of people in the West Midlands, and I just go in and just talk to them on an informal basis. And I think that's a real difference. We just share things earlier that we're thinking and invite views, rather than present a consultation paper, which I think the perception was in the past.
So if any of those things resonate with people in the audience, where they think, well, actually might be worth getting a group of practices together in whatever town may operate, and saying, well, look, come in and come to breakfast, as it were, that's an option for people to approach with. Okay, has that come as, did people know the SRA were doing that kind of thing? I've got I see one gentleman nod, not many nods. Do you?
Clearly you feel that the effort is being put in to make it more accessible, but there doesn't seem to be a lot of people in this room that knew about it, and has to say something.
So it sounds like we're doing lots of stuff, but just letting people know all the stuff that we're doing seems to be an initial thing to get over. Twitter's really interesting. I'm surprised that you haven't heard anything. We do a lot on Twitter. So Question of Trust, we did loads. I think very recently we did a Twitter hour on consumer credit and the new rules there. So we are quite active on Twitter. So I guess it's how to get firms to
Sometimes
get the links into us.
It's the activity that you do, isn't it? You know, who it is you're targeting. Is it the right people?
Yeah.
But if you follow the SRA on Twitter, I mean, they are very active.
But that in itself can be an issue, can't it? Because if they're very active, you won't necessarily read every tweet.
No, absolutely.
So then you need targeted information that is specific to you and your firm that you will read because it is relevant.
Yeah.
And it's not a criticism, it's an encouragement, really.
We are doing that a lot more. So another thing that we've done is we have lots of dedicated support and communications for small firms, based on feedback that small firms particularly struggle with regulations. So we have a small firms section of the website now. We have a small firms virtual reference group where we share communications and stuff with. We have a dedicated small firms part of our professional ethics helpline, and we have a specialist support team within our supervision unit. So we are trying to target and tailor those that need it. But yeah, obviously we need to keep getting the message out there and try and make more and more people aware.